Aho, Uda Shudade. Hello, everyone, and welcome to this roundtable discussion we are calling the Castro-Huerta Decision, Understanding the Case and Discussing Next Steps, hosted by NCAI and NARF. My name is Larry Wright. I am the Director of Leadership Engagement here at NCAI, and I will be moderating today's event. Before we begin the discussion on this important topic today, we want to start this event by getting ourselves in the right frame of mind. And to that end, we have asked Frank Edewagizik to start us off with an invocation. Mr. Edewagizik is the former tribal chairman of the Little Traverse Bay Band of Ottawa Indians and currently serves as the executive director of the United Tribes of Michigan. And we are honored to have him get us started off in a good way. Mr. Edewagizik?
Thank you. Ani, pipigwa dodem, waganaksing and donjaba, nakwe gijik, and disnakas. We thank the Creator for this beautiful day. We thank the Creator for all of life that we share in this world with. And we ask the Creator to be with each and every one of us that are on this call, with our families and with our communities, with our tribal nations. We ask that we all pay attention to the wonders that are in the world around us. We ask for blessings on all those who are ailing in body and spirit on this day. Ask the Creator to be with them and with their caregivers and to help give them the strength to face the challenges in their lives now. We ask a blessing on all of our leaders, all of our elected leaders, our spiritual leaders, and that leader that's in each and every one of us. We ask the Creator for guidance and strength that when we make decisions, we make them not just with our minds, but with our hearts as well. As we work for the future of Indian country and for the betterment of our tribal nations and all of our citizens, we ask the Creator to be with us as we think about and ponder these important decisions and information that we're going to get today. We ask the Creator to be with all those who are traveling through cyberspace today, to be at this, and ask for safe travel for everyone. We give thanks for all the many blessings in our lives. Miigwech, 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 miigwech. Aho.
Wiblahan. Thank you, Frank. Now, to begin our conversation about the case and to help us frame what we will be talking about today, we will start with opening remarks from NCAI and NARF. First, we will hear from Fawn Sharp, who is currently serving her second term as NCAI's president and also serves as vice president of her tribal nation, the Quinault Indian Nation. Thank you for starting off today's event. President Sharp, the floor is yours.
Great. Well, thank you, Larry, and thank you to everyone who is joining us here today. We come together in the spirit of sharing and in the spirit of connecting to one another about how we can collaborate collectively our inherent sovereign rights and for our futures. As Larry said, I'm Fawn Sharp. I serve as president of the National Congress of American Indians and vice president of my own tribe, the Quinault Indian Nation. Just over a week ago, last Wednesday, I was at NCAI headquarters there at the embassy in Washington, preparing for a series of meetings related to the Respect Act, to tribal sovereignty consultation, when the news broke. And we were all in disbelief as we sat there in the embassy. And within the hour, we had connections and phone calls all across Indian country. And the idea of having this roundtable was born. And so from that very moment of the news breaking to now, we know there's been a broad national conversation all across Indian country. We all felt the pain of that decision. We all felt the pain of what that might mean for our collective futures. And so we knew that there was no question tribal nations had to come together in this moment and in this hour, because it seems as though we've been working, and we have been working for centuries, for decades, to ensure that our futures are secure, to ensure that our inherent rights to govern our land, territories, and peoples exclusively belongs to us. And here we have a decision now where there's 3 layers of jurisdiction over a single instance. So with respect to non-tribals committing a crime against a tribal citizen, there is now tribal jurisdiction, state jurisdiction, and federal jurisdiction. Nowhere else in the country is that type of system created to administer justice. And it's at a time when we need to have certainty in protecting our missing and murdered Indigenous people. We need certainty as we engage in multi-million-dollar business transactions. And at a time we need it the most, and at a time when we've worked so hard to secure it, the very foundation is now shaken and 200 years unraveled. And so it is so important that we have a national conversation and that we come together. I want to take a moment to just give a little background about the Supreme Court's decision in Castro-Huerta, which brings such a large number of us here today. I know that in a few minutes, Mr. Zachary Schaaf, I think I'm saying his last name right, Schaaf, one of the attorneys who argued in front of the Supreme Court, will speak to us in more detail. But just to get us started, I think it's important to take a few minutes here to note some things about the case. On its most basic level, the Supreme Court held that states have concurrent jurisdiction with the federal government to prosecute non-Indian criminals who commit crimes against Indians in Indian country. This case happens because the state of Oklahoma said that Oklahoma police officers and Oklahoma prosecutors should be able to exercise their jurisdiction inside Indian country against an Indian, even though the federal government already has jurisdiction over such crimes. If you read the news about this case, some have claimed that this case is nothing more than a case about Oklahoma criminal jurisdiction, concerned with Oklahoma police and Oklahoma prosecutors, and dealing with Oklahoma politics. With all of those things are true, I want to make it clear that the Castro-Huerta is much more sinister than that. The Supreme Court's decision is nothing less than a direct attack on the sovereignty of all tribal nations. Prior to Castro, it had been unquestioned and understood for nearly 200 years that states do not have jurisdiction over non-Indian criminals who commit crimes against Indians in Indian country. After the court's decision, that is no longer the case. Prior to Castro, it had been understood for nearly 200 years that Indian country, while physically within the boundaries of states, was something unique and distinct from states when talking about jurisdiction. After the court's decision, that understanding is now up in the air. And prior to Castro, it has been understood for nearly 200 years that the laws of the states have no effect in Indian country unless and until Congress acts. After the court's decision, that understanding too is now up in the air. Thus, while Castro undoubtedly has a major impact on Oklahoma tribal nations, which is precisely what we'll be hearing from Principal Chief Hoskin of the Cherokee Nation and Principal Chief Halla later today, the fact is the decision impacts all of us, from my nation at Quinault to every single corner of Indian country where our communities are located. And today we are going to begin unpacking the consequences of this direct attack on tribal sovereignty and what it means to all of us. And as we do, I think it's important to keep our ancestors in mind and our history in our minds, because we have been here before. We have seen our sovereignty under attack, and we have understood for centuries that our inherent rights that we possess from the moment of European contact, they've been under direct attack. And each and every time that has happened, we have fought back. We have fought back fiercely, and we've fought back in a united way. Our ancestors paved the way for generations of leaders by fighting for the respect and recognition of each and every sovereign tribal nation possible. And today we continue that struggle and that fight. The Castro decision will not be the last attack on tribal sovereignty, and it will not be the last time tribal nations will rally to the call of history and take a stand for what we know is right for our nations and for our people. We are the strongest when we stand united. And as we move forward with today's discussion and have more conversation in the days and weeks ahead, and as we start to think about what action to take in response to this case, I think it is important and inspiring to remember that when Indian country is truly unified on an issue, when Indian country speaks with one voice, our voice delivers a very powerful message, and we are our strongest. Time and time again, we have needed to come together and deliver change, and we've found a way. Whether it was us coming together to fight against termination or to come together to fight against direct attacks, no matter where they occur across Indian country, or the need to fight for the right of our children to be raised in our communities, or to fight together to stop the courts from taking what is inherently ours. We have always done the difficult work of listening to one another, weighing out all the options, and then setting aside our differences in the spirit of the greater good. My hope is that today, It's that historic moment, the beginning, where we start down the path of a unified front, and we do not rest until our sovereignty is fully recognized and fully respected. The Supreme Court may have spoken last week about tribal sovereignty, but my pledge to you is that they have not had the last word on this topic. And I'm excited and truly honored to be part of this conversation today and to begin the discussion of what we want for ourselves and how we will get that and how we will deliver a future that our children so deserve. Thank you, Larry. Back to you. Siokwe.
Thank you very much for those powerful words, President Sharp. We now turn it over to NARF to provide some opening remarks as well. Please join me in welcoming Mr. John Echohawk, a citizen of the Pawnee Nation who has been with NARF since its inception in 1970. Mr. Echohawk has served as NARF's executive director since 1977 and continues to be one of the most influential legal minds in the country. We are honored that you have taken time to be with us here today, sir, and the floor is now yours for opening remarks.
Thank you, Larry. The Native American Rights Fund is very pleased to host this meeting today with the National Congress of American Indians. We've worked with NCAI for many years on these important legal issues. Since 2001, we've worked with NCAI on the Tribal Supreme Court project, and that was formed in response to a series of U.S. Supreme Court decisions which had negatively affected tribal sovereignty. And the purpose of the project is to promote greater coordination and improve strategy on litigation that might affect the rights of all tribes. In addition to that, I've been very honored for many years to serve as chairman of the NCAI Litigation and Governance Committee. And in that role have helped NCAI develop policy positions on all of these major litigation and governance issues. And that's usually done through a process at the conventions where resolutions offered by tribal delegates are considered. And as President Sharp was talking about, we really strive to reach consensus and unity on these positions and have our discussion as long as it takes to achieve that unity and consensus on these major issues. And we're very hopeful that we'll be able to do that today as we start discussion on the next steps after we come to a full understanding of the case. So once again, the Native American Rights Fund is very pleased to host this meeting with NCAI and promote this understanding and initiate this discussion. Thank you, Larry.
Thank you, sir. And when we thank you both, Executive Director Echohawk and President Sharp, for your opening remarks and providing us with an overview of today's discussion. Before we move into our roundtable discussion about the case, we've asked Mr. Zachary Schaaf, the attorney who argued the case in front of the Supreme Court, to join us to provide some context about the case. Mr. Schaaf is a partner at the law firm Jenner & Block and has represented tribal nations before the Department of Interior and all levels of state and federal courts, including the U.S. Supreme Court, on issues related to sovereign immunity, federal preemption, and gaming rights, just to name a few. Mr. Schaaf, thank you for joining us today. We're all looking forward to hearing what you have to say about last week's decision.
Thank you. I really appreciate the chance to be here. And it's humbling, really, to be part of such an amazing panel of tribal leaders and scholars. I did have the privilege to argue the Castro-Huerta case. And, after writing the briefs in McGirt and Murphy, I'm, of course, bitterly disappointed by the results. And, I have to say, NCAI and NARF have taken a big risk in putting me up close to the beginning, since there's a risk I could just hijack the whole session with my 95 theses about everything that the majority got wrong. But I'm going to resist the temptation. Really, what I'm most excited to hear today is the thoughts of the amazing group of leaders and scholars we have here. So mostly, I'm just going to try to get on the table what happened in the decision and then get out of the way. So I think there are really two ways to look at where this case came from. One, you can look at the discrete legal question that the case presents, which, as President Sharp mentioned, is a question of criminal jurisdiction. Who has jurisdiction over crimes by non-Indians against Indians in Indian country, and in particular, whether states have concurrent jurisdiction with the federal government. The settled understanding for 200 years had been that states lack that jurisdiction, but nonetheless, the Supreme Court had never squarely addressed that issue in a case where that very question was squarely presented, and so in that sense, it was open. But I think the second place where Castro-Huerta came from, and the reason really why that issue came before the Supreme Court now, after 200 years, is McGirt. As everybody here surely knows, McGirt held that Congress never disestablished the Mvskoke Reservation in Oklahoma. And as everybody also knows, since McGirt was decided, the composition of the Supreme Court has changed. Justice Ginsburg passed away and was replaced by Justice Barrett. And Oklahoma saw this too and embarked on a campaign to overrule or at least limit the McGirt decision. They hired a white shoe New York law firm, Paul Weiss. They filed dozens of petitions asking the Supreme Court to overrule McGirt. That led to a massive effort to fight back against that campaign, including many of the folks and organizations on the call here. The Cherokee, Muskogee, Choctaw, Chickasaw, all 5 tribes, I think, filed briefs at the cert stage. I myself, I think, filed about 40 briefs in opposition, and the Supreme Court said, no, we're not going to revisit McGirt here, but we are going to hear this narrower question about jurisdiction over crimes by non-Indians against Indians on reservations. And I do want to pause on this point because, we're not going to like how the court resolves that question in this case, but it was a massive and important win to get the McGirt issue denied, and we shouldn't lose sight of that as we collectively gird ourselves for the fights ahead. This is not what Oklahoma had in mind when it paid, I think, $1.5 million to try to get McGirt overruled. It did not succeed in that attempt. And that's particularly significant because, as we have all learned over the last several weeks, this is a court that is not shy about revisiting precedent when it thinks that precedent might be wrongly decided. But nonetheless, the court did take up a narrower question in Castro-Huerta. And as everybody here knows, the court held that states have concurrent jurisdiction over crimes by non-Indians against Indians. It's a 5-4 decision, with the new Justice Barrett, joining the 4 dissenters from McGirt. Justice Gorsuch dissented, joined by the 3 remaining members of the McGirt majority. And the decision relies heavily on this presumption that states have the criminal jurisdiction at issue here unless some statute displaces that jurisdiction. And the core of that is the language that I know really came as a body blow to many people here, the place, or one of the places anyway, where the pain that President Sharp mentioned came from. This statement that Indian country is part of the state, not separate from the state, and that as a result, states have criminal jurisdiction within their boundaries unless you have a preemptive statute. Now, the court tries to piece together some statements from prior cases to support that presumption, but as Justice Gorsuch shows in his dissent, the claim really is very problematic. It is not well rooted in history. At the founding, Indian country was viewed as a separate place entirely. It is not rooted in Congress's understanding in the early republic. So Congress enacted the General Crimes Act for the first time in 1834. At that point, Worcester versus Georgia is hot off the presses, saying that states lack exactly the type of jurisdiction at issue here. That presumption is not rooted in treaties or the trust relationship, both of which presume that the federal government and only the federal government will be the one who prosecute crimes by non-Indians against Indians in Indian country. And it's also not rooted in the text of Congress's more recent statutes. As folks here know, some states do have jurisdiction over crimes by or against Indians in Indian country under Public Law 280 and similar jurisdictional grants. This statutory text, you just have to read it. It presumes that states lack the sort of jurisdiction at issue here, because otherwise you'd never need to give them jurisdiction over crimes by or against Indians. And finally, the presumption that the court applied in Castro-Huerta isn't rooted in the court's own statements either. As I said, the Supreme Court has somewhere between 6 and 12 times stated that states lack this jurisdiction. And normally we assume that Congress legislates against the backdrop of what the Supreme Court has said. And indeed, it's worth pausing on how the court dismisses its own prior decisions, especially Worcester itself. The court says basically that Chief Justice Marshall got it wrong, and the court has moved away from Worcester. Now, of course, as we all know, there's a kernel of truth to that, and that the court no longer applies this rigid idea that Indian country is entirely separate and that state laws can never have any force there. But even as the court has done that, it has emphasized that state law gives away extraordinarily easily in Indian country, because Indian country is not a place for states to govern. And yet the majority in McGirt fundamentally lost sight of that latter proposition. Now, we don't know why the court departed from this historical understanding and applied the presumption it did, but one thing that's certainly prominent in the decision, and that we'll probably talk about more, is a certain view of some disputed factual claims that Oklahoma made. On the one hand, Oklahoma said that McGirt has caused law enforcement chaos in eastern Oklahoma, which Rebecca Nagel, among others, has done extraordinary work casting doubt on and showing it's just false. And on the other, the court believes that expanded state jurisdiction will fix, or at least not hurt, the problems it sort of invents with respect to law enforcement, which is quite a claim to anybody familiar with the history of these jurisdictional transfers, including Public Law 280. So that's the decision. And with that, I want to hand the mic back to our tribal leader panel. But before I do, I want to say one last thing, which is that I know this decision is difficult to read, but that's not a reason to be downcast in the fights ahead. We have thus far collectively prevailed against the attempts to overrule McGirt. And we know from another case last term that Justice Barrett is an available vote in tribal cases. She voted with Justice Gorsuch and the other members of the McGirt majority in the Ysleta del Sur decision. And we are, of course, bitterly disappointed we did not get her vote in this case. But fundamentally, the meaning and effect of the Castro-Huerta case will be decided in future cases. And we have many, many arguments to press on why this decision should not stretch any farther than the discrete issue the court decided here. And I, for one, am looking forward to the fight ahead and also to the rest of today's panel.
Thank you, Mr. Schaaf, for providing us with more context and background on the decision. And thank you for agreeing to stick around for the Q&A portion of the discussion a little later on. At this point, we are going to bring in some tribal leaders and begin discussing what this decision means to them and their communities. With us today are Chief Chuck Hoskin Jr. of the Cherokee Nation, Principal Chief David Hill of the Mvskoke Creek Nation, and Fawn Sharp, Vice President of the Quinault Nation. And the first thing we're going to do is let each of the three of you provide a few minutes of opening remarks about the case and its potential ramifications for your communities. Chief Hoskin, we'd like to start with you. Can you talk about what this case means to the Cherokee Nation and its citizens?
Well, Larry, thank you very much. Thanks, everyone, for their time and attention to what is a critically important subject. Reading the dissent in this case, I think, ought to be required reading for anyone in the country with an interest in this case, because it really drives home what the majority missed. And the gentleman on before, of course, gave an excellent recitation of the analysis and where the court fell short. But think about Samuel Worcester and think about the Cherokees in the 19th century. Think about the fact that Samuel Worcester was arrested for living among the Cherokees, and Georgia tried to apply its law to him and his status. And the Supreme Court said that the laws of the state of Georgia shall not apply. That bedrock principle, even though there has been certainly changes and some whittling away at it over the 2 centuries, was such an important principle of federal Indian law. And for the court to, as the dissent said, wilt on that basic proposition is, I think, heartbreaking for us in Indian country. But what's true is that before this case came out, before Castro-Huerta, and the day after, one thing has not changed, and that is that tribal leaders and tribes must continue to fight for sovereignty. We're going to fight in the courts. We're going to fight in legislatures, fight in the Congress. And we've got to remember that in the long run, we are still on a path of progress. We are still on a path of regaining sovereignty. The historic win under the McGirt case fundamentally stays in place. Of course, we know that we've got to be on guard to keep that in place. So it's a mix of feelings that I have about this. Certainly the decision was wrong. Certainly it goes back, the court goes back on its own principles. Certainly it attempts to make, I think, out of whole cloth this idea that the imposition of the state of Oklahoma over tribal lands somehow changed such a fundamental character of tribal sovereignty and really made state sovereignty in some respects superior to tribal sovereignty. Certainly that is troubling, but the fact that we have fought so hard and come so far, I think is a reminder that we've got a lot of fight in us, and we're going to need it in the days ahead. There's going to be a lot of cases that go up to the court, and the application of Castro-Huerta will be critical. How it's applied to future cases that go up there, how it applies to treaty rights cases that may emerge. So that's something we have to continue to fight for. I do want to note that and I'm not alone, was concerned about just going into this court with some change in its makeup was risky, but it's something we certainly had to do. And I applaud all of the attorneys and the legal team who put forth what I thought was a brilliant and winning case. But avoiding this court is sometimes a good strategy. And I will always regret that we were not more successful in getting Congress actually to pass a bill that would have protected and, in fact, codified 100% of McGirt and given us options to, if we wanted to, compact on this very issue. I believe had we been successful in that regard, that the Supreme Court would not have even taken this case. They would have looked upon the Congress and the tribes of having crafted a potential solution that kept all of McGirt in place, given us new tools to compact if we wanted to. And I think we could have avoided what is an outcome that's going to have long-term implications for Indian country. And that's all hindsight at this point. That's all water under the bridge. But I will always have that regret that we didn't achieve success in the legislation we put before Congress. Going forward, in addition to fighting to protect our sovereignty, here's what else we have to do. Tribes that fall under the McGirt case, and this is true across Indian country, of course, where tribes have this obligation, we have to build up strong, effective, and fair criminal justice systems. That work is still vital, and we're undertaking that work at the Cherokee Nation. So as concerning as this decision is, we've got to remember as tribal leaders that we've got an obligation still to meet. We have an obligation to bring justice for victims. That includes victims of non-Indians who commit domestic violence crimes. That's still very much intact under the Violence Against Women Act. We still have a responsibility to assert criminal jurisdiction over cases involving Indian on Indian crimes. That is a big obligation that we're scaling up our criminal justice system to meet. So we've got to continue to fight for sovereignty, and we've got to continue to build up our criminal justice systems. If we can look for ways, whether legislatively or through the right case that comes up, to try to go the other way and whittle away at this terrible decision, we ought to do it. We ought to do it strategically. We ought to do it thoughtfully. But in the long run, I think we should all remember that we are still on this path of progress. We are still making progress in Indian country. We shouldn't lose sight of that. Thank you all.
Thank you, Chief Hoskin, for that perspective. I'm going to turn now to Principal Chief Hill of the Mvskoke Creek Nation and ask the same basic question. Obviously, both the McGirt case and this recent decision have had huge impacts on your nation. Can you tell us about how you see these recent developments affecting your nation and your people?
Thank you, Larry. I hope you can hear me. I had a little sound mix up earlier, but as you know, the Mvskoke Creek Nation has been at the forefront of this battle. It was our lands, and that were affirmed in Supreme Court ruling, the McGirt case. Actually, this Saturday, July 9th, was a historical day for Mvskoke Creek Nation, and also as well as a historical day for all Indian country. And let me tell you, it's been a fight every day since. This latest Supreme Court decision is the latest round in that fight. We believe this is a step in the wrong direction for public safety on our reservation and every reservation in the country. We don't have to guess whether the state will prioritize public safety on a reservation. For over 100 years, the state of Oklahoma illegally exercised jurisdiction, and they did not. That is why we believe the best solution is to empower those who are most motivated to protect our citizens, and it's tribal government. We believe we should have the authority to prosecute any crime that happens on our reservation. We believe that outdated sentencing caps should be lifted to further empower us to secure public safety. Doing so would enable us to ensure there are no gaps in prosecution. Doing so would provide more public safety. It's hard to see any reasonable justification for opposing more public safety resources. I recognize there are a lot of ideas and emotions swirling around right now, but I believe strongly that further empowering tribes to protect all citizens should be at the heart of any next step. But we are going to have to be strategic and smart and understand that this fight may take a long time. But we, Mvskoke Creek Nation, are up to the task. We look forward to working with our legislative allies and all of you on this call to find solutions. And basically that's basically that's it. And thank you, Mado, for joining, and thank you for the invitation. Mado.
Thank you, Principal Chief Hill. You and Chief Hoskin have raised a number of very important issues, and hopefully we'll be able to talk about several of them in more detail during the Q&A portion of this event. For now though, I'd like to, I want to give President Sharp an opportunity to speak a little more specifically about this case in her community. President Sharp, you already gave some opening remarks about the decision, but can you discuss what you see as some of the major implications for a tribal nation outside of Oklahoma, such as your tribe, the Quinault Indian Nation?
Yes, absolutely. Thank you, Larry. Thank you for that question. And some of the things that I am very concerned about, just in thinking about our future, is when you consider an institution like the United States Supreme Court, and that entity that we have long looked to be that independent, objective arbiter of justice that's neutral, that relies on precedent, stare decisis, means something. To think that level of trust and confidence in an institution foundationally has just been shaken, it calls into question from our perspective, what about the other areas where there's so much uncertainty in Indian country? And when I think about that question, I think about our ability to build our tribal economies, business laws, taxation, all of those other things that we know to be true beyond basic governance of our land, territories, and resources. We want to step out and build our economy, exercise tax jurisdiction so we can secure the resources that we know have been long forgotten, and a breach of trust by our trustee to fulfill basic obligations of health, safety, and welfare, as evidenced in the Broken Promises report. And when you look at examples across Indian country, and I'll just point to examples in my area, the Tulalipes in building and envisioning Closita Village, or the Chehalis tribe with a Great Wolf Lodge, after investing millions of dollars into these projects, here comes the Thurston County and here comes the state of Washington after the fact to tax. And so how do we engage in commercial and business transactions with any level of certainty if the entire foundation of law and policy as it relates to tribal nations and state jurisdiction and regulatory powers, civil enforcement, at a time when we're trying to recalibrate our economies, rebuild after COVID, where tribal nations have been experiencing the highest rate of death and infection, and rebuilding our economies. We have come a long way, and I felt very strongly, and I still feel strongly, that we are poised to continue to make those advancements. But if we try to seek to build that structure within our nations, and we have the degree of uncertainty that this case has created, not only for purposes of the foundations of federal Indian law, but going forward, how are we going to do that? The other thing that I'm very concerned about is the Quinault Nation is a party to the Brackeen decision. And what does this case mean for the Indian Child Welfare Act case that will be heard next term? That's very concerning. And then, of course, VAWA, the Violence Against Women Act, the work that NCAI has done over the years, we've utilized VAWA as that legislative vehicle to restore piece by piece that which was stripped and taken away in the Oliphant decision. We've had some degree of certainty there in our ability to enlist bipartisan support, to unify our voice, to restore jurisdiction. But if we do all of that work, both policy work, legal work, economic work, to restore that which is taken, and it takes one decision to completely unravel 200 years of effort, that's very concerning about the future. But one thing is for certain, while there's all that uncertainty, as I said in my opening remarks, there's no question we know exactly who we are, the powers that we possess inherently that no one can take away, with or without states, with or without the United States. We have a vision for building our future. And as we work through the ebbs and flows of policy and political change, we're going to remain standing, and we're going to remain strong. And it's events like this that are going to unify our effort. And so those are some of my thoughts, Larry. Some of the things that I've been thinking about since hearing about the decision, and certainly thinking about it in the days since. But we're ready, we're confident, and I'm just so very grateful. We've had nearly 1,000 registered for this event, and all of Indian country stands together. So thank you, Larry.
Thank you, President Sharp. And thanks again to all three of our tribal leaders for being here today and giving us some early insights into how this case is impacting tribal sovereignty and our Native people. In just a few minutes, these leaders will be answering your questions. So please use the chat and or the Q&A box on Zoom to submit your questions, and we'll try to get to as many questions as possible. Before we start that part of the discussion, though, we thought it was important to bring in some legal experts who could also provide us with more information about what this decision might mean throughout Indian country. Today, we are pleased to welcome Ambassador Janadev Chaudhary of the Mvskoke Creek Nation, Professor Elizabeth Reese from Stanford Law School, and Melody McCoy from NARF. As we did with the tribal leaders, we're going to give each legal expert a few minutes to talk about the ramifications of this decision. We will start with Ambassador Chaudhary of the Mvskoke Creek Nation, who, in addition to serving as his nation's ambassador, is currently the principal at Chaudhary Law and has not only served as a tribal judge in the past, but was also appointed and confirmed by the U.S. Senate to serve as the chairman of the National Indian Gaming Commission from 2013 to 2019. Ambassador, drawing from your diverse experiences, could you please provide some initial thoughts about what this case means moving forward?
Well, Mado Chairman, I'm deep gratitude to NCAI and NARF for hosting this important discussion. I just want to clarify very briefly, I'm here in more of my personal capacity. Although I do serve as ambassador for Mvskoke Creek Nation, I will be speaking from a policy perspective regarding where we go from here. How do we see getting solutions done, and what is the political path ahead? But in terms of our legal team, I do want to give deep and appreciation to the General's Office, as well as Riaz Kanji, who argued McGirt for us before the Supreme Court and worked with Zach and others in developing arguments in Castro-Huerta. So a few things. I know we're going to hear from Professor Reese shortly and Ms. McCoy, and they're going to get into some more detail in terms of the legal intricacies of this case and where we move forward. But from a policy perspective, I want to share a few thoughts about terminology. Terminology is very important, whether or not the battles ahead are in the litigation arena or in the political arena. And in that regard, let me just say, as Zach properly pointed out, the immediate impact of this case is narrow. And I believe it's important for us to narrow the impact of this case wherever possible, because the potential for confusion among federal and state courts is high. We can see federal and state courts mistakenly extending the dicta in Justice Kavanaugh's opinion. And so I think as we talk about the actual direct effects of this case, it's important to narrow the scope of the immediate impacts of this case. So just for myself and others I've been talking to, people have been talking about the Kavanaugh dicta. Now, that's not to say that the case doesn't present clear and impending dangers for Indian country and for Mvskoke Creek Nation and others, because there is this broad language set forth in the decision. And let me talk about that broad language. I think we've already heard folks talk about the litigation battles ahead. In the legislation field, Creek Nation and other voices have been pretty consistent in saying there was never any litigation necessary to address McGirt. In terms of compacting, legislation wasn't necessary. There were already avenues available for tribal nations who wished to compact with tribes. There were actually avenues, although politically distasteful, avenues, as Justice Gorsuch's dissent references through Public Law 280, for tribal nations to work with states and give states jurisdictions should they choose to do so. So Creek Nation and other nations across the board were pretty consistent about standing firm against legislation. But in this post-Castro-Huerta moment, I think there is quite a bit of discussion about legislative engagement. And as we talk about legislative engagement, I think it's important to recognize that developing coalition on both sides of the aisle will be critically important. Now, this case has been tied to other cases in the media involving other areas of subject matter and been tried to put in a broader context of Supreme Court activity. I would caution against tying this case to other cases for a couple reasons. As has been pointed out already, and Justice Amy Coney Barrett has sided with Indian country on some critical cases. Ncei, Isla del Sur, by no means has she been a guaranteed anti-sovereignty vote. Her position in this case was extraordinarily disappointing. But further than that, Justice Gorsuch's dissent highlights the importance of engaging with folks on both sides of the aisle who truly understand where Indian law comes from. The fact that Indian country's rights are inherent sovereign rights that predate the Constitution of the United States. That was just doubled down on in the Ncei case. That still needs to be a theme that is pressed heavily, whether it's in legislation or litigation. Now, finally, in terms of the language that's used as folks engage in legislative thought, I think it's important to not talk about fixes. One helpful frame of reference as people think about where to potentially park any clarifying legislation or how to address clarifying legislation is the 1991 Duro clarifications that are out there. I know some people refer to that as the Duro fix, but what that case was about, it was about Congress clarifying some of the questions that had been raised in the Duro case, and it was a clarification. Having swam in the policy waters for many years now, both from an agency head perspective as well as somebody who's part of a larger policy team, it's important to frame our efforts as solutions that are targeted to enhancing public safety, to going after bad guys, to building a better future for everyone within our reservations. So I would just suggest that we stay away from language such as fixes and focus on legislative engagement for the purpose of working towards solutions. And with that, I think even folks that you wouldn't think of as natural Indian country allies would be on our side if the ultimate goal is to improve a better future for everyone within our borders. So I thank everybody for their time, for the opportunity to join you all today. I'm happy to go into more details, but I know one solution that has been proffered primarily by Justice Gorsuch in his dissent is helpful. It talks about clarifying that states can only exert jurisdiction if they avail themselves of public 280 measures. And that's helpful. But if we're really talking about public safety in the country, that's going to require relaxing some of the restrictions that historically have been there on tribal nations as they try to prosecute crimes on their lands and set sensible public policy. So our suggestion would be to certainly be realistic in terms of what can be done through the legislative process, and we should have some very discreet, frank conversations about what can be done, but at the same time, not be self-limiting. I know there are often concerns about, well, we can only do so much. Let's take what we can win. But as a collective team, being self-limiting too early has consequences. Addressing some of these limitations on our ability to prosecute crimes, on our ability to sentence bad guys, coupled with this idea that Justice Gorsuch referenced, may be helpful. So, if anybody wants to kind of reach out discreetly, you can contact us. I don't want to throw Chief under the bus, but my email is jonadev@chowdhurylaw.com. Happy to talk in greater detail, but just thank you all for this important opportunity, and I look forward to the Q&A. Mado.
Thank you, Ambassador, for your insights. And I want to now turn the floor over to Professor Elizabeth Reese, a former NCAI employee who is now a professor of law at Stanford University. Just yesterday, Professor Reese published an op-ed about the decision in the Washington Post. And I'm wondering if you could now talk to us about what you wrote there and how you understand this case to be an attack on tribal sovereignty.
Yeah, thank you so much, Kunda. So Navito Hawaii Ampovi, Navi Americana Hawaii Elizabeth Reese, Na Nambe Wenge Weang Omu. So thank you all so much for having me. Of course, sad that I have to be here under such circumstances. Like many folks have said, I am very concerned about this decision and certainly felt the body blow that reading a lot of the language in Kavanaugh's opinion was. So as a legal scholar, I think I want to offer just a few different points of insight. So I also encourage you to read. I have two pieces out about this opinion, one in the Washington Post that I think highlights, or that I wrote along with my colleague at Stanford Law School, Gregory Oblavsky, who also wrote one of the amicus briefs in this case that focused on the legal history that led up to these jurisdictional fights. And in that piece, we really talked about how sad and frustrating this opinion is as legal scholars who are really aware of the full history of Indian law and what it meant to start with Worcester versus Georgia, and that being a case that is, fully rooted in the need for tribes to be independent, self-governing nations, because when states are allowed to interfere with tribal land and tribal sovereignty, like that is how they get up to the type of mischief that can interfere with our right to self-government in the ways that can lead to the Trail of Tears. Because, that is the story of Worcester, is that states were actually using their, exactly the same power to criminally prosecute non-Indians in this way do that, to go after allies of tribal folks in Georgia. So we talk about that in that piece. And then I have a piece in The Nation that just came out yesterday that's also a bit more of a like personal tragic reaction on what this means following up from McGirt. And so I, take a look at either of those as well. But I want to follow up on what the ambassador said, to really emphasize that it's important to think about what this means and what it doesn't mean. Because, right now, just like right after McGirt, there is a legal holding that is precise and narrow. And that is that states now have jurisdiction over non-Indian crimes committed against Indian people. But that is it. And it does not mean that any of the other broader implications of the reasoning, which, I think I disagree a bit with the ambassador in that I think we're going to have a hard time trying to deal with whether or not this is dicta, because the court was pretty explicit about trying to make part of that tied within its holding about a state's territory, including Indian country. And so looking forward, that is sort of the challenge that we are going to have to confront, is what to do with that language and what the repercussions of that will be going forward. But it's important to think about that as the next fight, as tomorrow's fights and tomorrow's court case fights, because there is a possibility for legal confusion on the ground right now. And so we need to be really careful to make sure that that doesn't happen, because there are real lives at stake. If there is uncertainty in Indian country right now about who's, what police to call, what police need to show up, what prosecutors are in charge, et cetera. And also because I think there's a really, really important opportunity that tribal leaders and other folks who work in Indian country can seize on right now. And that is to have a very quick reaction, to meet with the state officials who have this new power, and start talking about what that power looks like and whether or not they even want to exercise it. Because even though they have jurisdiction, they don't have to use it. They don't need to be prosecuting these crimes. And so many states may choose not to, or they may choose to work out some kind of arrangement working with the tribes and with the federal government in a way that is far more cooperative and ultimately better for everyone involved. If, tribes make sure that we're at the table and even at the driver's seat, convening a lot of these meetings right now to try and make sure that things are workable right off the bat, as opposed to, just letting states figure this out on their own. So I really encourage those of you who are in those positions across Indian country to try to do your best to start convening those meetings and building those relationships. Because I think it's one of the best practices that has been shown is that type of collaboration. Then the last thing I'll say about this is just, what does it mean about maybe this Supreme Court and arguing before the Supreme Court going forward? So this is certainly a really concerning decision. I think it means that we have to be very, very careful as we're arguing things before this Supreme Court. This is certainly a very different court now with Justice Barrett instead of Justice Ginsburg than the one that decided McGirt. And I think, zooming out of just Indian country, I think one of the takeaways that, I have as someone who watches the court is that this is a very young court compared to the court that we have had maybe 5-10 years ago. And so these are a lot of young justices who are, particularly in areas of law like Indian law, they don't know it that well, and so these are some of their first big Indian law decisions. And so I think with a court that's this young, and I think frankly like a little bit arrogant and willing to be bold, we're at risk of getting decisions exactly like this one, where there are broad statements, sweeping statements with large implications that are driven by this sort of overconfidence in sort of young justice mindset, and not the sort of, rooted in precedent. This is my, 15th Indian law decision that you get with I think some of the older courts once they've been around for a while. And so I think that means that it's really, really important that when we argue these cases, we make really clear what the stakes are and do as much educating as we can about this fuller context. Because I think part of the story of how this came about was, how much the state of Oklahoma was sort of pushing for this narrative of the context that they were telling. And so I think that that's part of how we should be thinking about what this court is going to be like for Indian country going forward. Is we're in a position of really trying to do some basic educating with especially some of these new justices other than Justice Gorsuch. But in the end, I'm also not even sure it really matters. And so the last thing I'll say is that, I don't know, I'm sort of a little torn on whether, a lot of times I think when we have had really big losses in Indian country, particularly Supreme Court losses, we have been alone, and very few people have paid attention. And the fact that our precedent has changed on us and the court has sort of disregarded the rule of law for us has been a sort of singular loss. But I think that is a more broad sentiment in the country right now. And I think we are going to have to decide a little bit whether to sort of join a chorus on questions of sort of court reform or not, because they are starting to bubble in a way that I think is definitely new for this country, and that might be worth considering.
Well, thank you very much, Professor Reese, for those comments. Our final legal expert we will hear from today is Melody McCoy, who is a staff attorney with NARF and who recently took over directing the Tribal Supreme Court project, which seeks to strengthen tribal advocacy before the U.S. Supreme Court by developing new litigation strategies and coordinating tribal legal resources. Ms. McCoy, we have now heard from several leaders and legal scholars about the implications of the decision. Are there other aspects of the decision that you think tribal nations should be aware of moving forward?
Thank you, Larry, and thanks to NCAI for allowing me this opportunity. I was asked to, and I'll answer your question, I was asked to also speak to the immediate implications of this Castro-Huerta decision, as well as some long-term. So I'll start with the immediate, which is, of course, the need to understand it, which is what NCAI is helping us all do here today, and the Native American Rights Fund stands ready, willing, and able to do that as well, so that tribe leaders can and their attorneys and decision makers can identify and understand, viable options at this point about what is the existing state of the law, as well as what, if anything, would be done going forward. So the first thing that occurs to me is that it would behoove us to understand what, if anything, is left of the federal preemption argument, because even the majority in this case, of course, says that federal law can preempt this state jurisdiction that they've upheld. And there were only two specific federal laws involved in the case, the General Crimes Act and Public Law 280. But that leaves a host of treaties. Other federal laws could be general, could be tribe-specific federal laws like allotment acts. Public Law 280 like laws in states like Kansas and New York. Land Settlement Claims Acts, et cetera, and even state enabling acts. I know the dissent in particular looked at Oklahoma's enabling act. But all of these need to be examined, I think, to determine what, if anything, is left of the preemption argument. I think that's very important. The other thing, of course, is, and this is again something that the dissent alluded to, is state laws. So there's 35 states of the 50 that have federally recognized tribes within their borders. And I think it's important to now take a look at state laws and see if there's any state law impediments to this state jurisdiction. So I'm thinking of state constitutions and state legislation. I think it also is important to take a look at the is there anything left of the majority's holding that at least in theory, tribal self-determination could preclude state jurisdiction over crimes committed by non-Indians against Indians. I don't know what that would look like, but perhaps there are those that could help shape that inquiry. Again, these are just, to understand all of this information, I think will help tribe leaders and decision makers reach consensus, knowing what is the existing state of the law, help them reach consensus and make good decisions about going forward. So in the long term, of course, the court cases, some are easier to control than others. And as far as, going to the United States Congress about something to do about this, I have no doubt that there are members of Congress that would be willing to take this up and help tribes with this. I think the important thing has been well said, is that tribes come together on what it is that they might want from Congress. And I don't think we know quite yet what that looks like, but that's what we're undertaking. And that's a large thing. I think the other thing is to really quickly as possible get a handle on where the states are on this. There were only 5 states that supported Oklahoma in this case: Texas, Louisiana, Kansas, Nebraska, and Virginia. So I expect those states, having spoken their views, are going to stick to those. But that leaves another 30 states, like I said, with federally recognized tribes within their borders. And I just don't know where they are on this. It's new to them as well, because I think they are most likely operating under assumptions more like those of the dissent, that they don't have this jurisdiction. And again, some of them in their own laws may have addressed this and said, we don't want or we don't have this jurisdiction. So I think it's important quickly, and I guess, the usual ways of finding out where states are on this are, the state's attorneys generals, governors, law enforcement, legislatures, conferences, meetings, and you all know this somewhat better than I do, but I also think of other state agencies because, again, this is about state criminal jurisdiction over non-Indians who commit crimes against Indians. But when I think of crime victims, I often think of, youth, elders, disabled. And I think that some of the agencies at the tribal and at the state level are much more in touch with, what are the views of those agencies in terms of what can be done, what should be done. So that would conclude my remarks. And again, thanks for the opportunity to address everybody today.
Thank you very much, Ms. McCoy. I appreciate those remarks. And I want to thank all who've given us some time, given us some starting points for our discussion about this case. At this point, we are going to transition into answering questions from our attendees. As a reminder for all of our attendees, you can submit your questions for the panelists via the Zoom chat box or the Zoom Q&A feature. If your question is directed to a specific panelist, please note that when you submit it. We will try to get through as many questions as we can, but we'll also keep a record of everything asked here today in hopes of providing additional information in the future on the issues that matter to all of you the most, and with respect to this important case. So with that, we will turn to our questions that have been submitted, and I want to thank our staff for being able to put these together and condense them. And so for our panelists, we'll start with the first question that we have. We have received many questions about this case and how it will impact the on-the-ground efforts of tribal nations prosecuting non-Indians under the Restored Jurisdiction 1 in VAWA 2013 and soon under VAWA 2022. Since Quinault Indian Nation, Muskogee Creek Nation, and Cherokee Nation all prosecute VAWA cases, can you speak to these on-the-ground impacts this case may have on VAWA investigations and prosecutions?
I'm not sure if others want to speak, but back to the point that was raised about the impact of the case on the preemption analysis that was kind of introduced into the area of criminal law. The hope would be, and I would direct folks to look at footnote 2 in Kavanaugh's decision to at least see where superficially Kavanaugh is distinguishing his analysis from other areas of law. But I would submit the sensible approach would be to say Castro-Huerta applies to General Crimes Act. That analysis should be put into a box and not let out of the box. Any express recognition of inherent authority of tribal nations to prosecute crimes, such as the recognition that existed in the VAWA reauthorization, should be untouched. That would be the argument that I think a lot of folks would make. The concern is that courts will be confused and will get it wrong and will unlawfully broaden the impact of Castro-Huerta. So the battle is going to be how broadly this gets applied. But that's a specific grant or recognition of authority from Congress. The hope would be that it wouldn't be touched.
And if I could, Larry, I think even before it gets to a court, we're going to have some issues with just the the frontline law enforcement and the prosecutor's offices. So I think it's going to call on the tribal leaders, tribal law enforcement officials, tribal prosecutors to really be engaged with their counterparts in the other jurisdictions to make sure that they understand that VAWA is alive and well, because I know there'll be confusion, because coming out of the gates on McGirt, there was a great deal of confusion for the people that I have a great deal of sympathy for, which is rank and file law enforcement of any jurisdiction that's just going out there trying to do their jobs and trying to absorb what is really new and unfamiliar information. So I think we can do our part to inform their understanding of the continued viability of VAWA.
Thank you.
Yeah, I think it's so when I was working at NCAI, I worked with the implementing tribes across the country and wrote the 5-year report on VAWA. And I really want to echo, especially what Chief Hoskin just said, because I think that one of the best practices that we saw and continue to see with the implementing VAWA tribes right now is that building relationships across jurisdictions is really important, and that's not just with the feds, but also because currently there are implementing VAWA tribes in PL 280 states, which means that they're working really closely with the states who already have this jurisdiction and have had it since 1953 under PL 280, and so that's certainly possible and can be really, really important. I do think even though VAWA is still good law and remains good law for tribes to implement today. So I do think it's also important to flag that we should be really careful going forward to make sure and not let there be a sliding argument that the next VAWA is unnecessary, or that a full Oliphant fix is unnecessary in light of this decision or further expansions, because that is certainly a huge worry that I had when I saw, just the first cert grant, or also, certainly this decision, is that, at some point the court might look at, this increased state authority and start thinking, well, what's the point of even having tribes if the states are doing all of this work? And that would be a huge tragedy, right? Is if that started being how things started creeping in, and how we ended up losing really, really important fights. And so I think that is something to be aware of and be really, really on top of to make sure that doesn't happen.
Yeah, thank you. Thank you for all those answers. We'll move on to our next question. We've also received many questions regarding the impacts of this decision on tribal nations in different states. And I know that was addressed a little bit earlier, but while we're still unpacking this decision and knowing that potential impacts can vary greatly depending on the specific tribe, tribal territory, and the tribe's relationship with the state, can you discuss some of the potential impacts in different states and situations in Indian country and what tribal nations can do to be proactive? And I know you spoke briefly on PL 280 and what that may, how that may be affected too. So I'll turn that over to anyone who'd like to take a shot at that question.
So I'm happy to say a few words about it. You know, I think one piece is that under Public Law 280, states already have this jurisdiction, and there's other similar jurisdictional grants that, you know, stretch across, you know, 20-something states. And so, you know, this decision will not have a direct impact here. The impact, you know, if any, is going to come from, you know, ways that states or folks who are aligned with the sort of states' rights perspective try to use the broad language in the decision. You know, those arguments are coming. I think we should all be ready for it, but it is not a direct effect. And, you know, those arguments we fought out in future cases. You know, in other states, you know, there's a back and forth between Justice Kavanaugh and Justice Gorsuch about exactly how broad, you know, this decision is. I think, you know, a fair reading of the majority is that, you know, it is a nationwide ruling, at least in terms of the sources it considers. So, you know, Public Law 280, the General Crimes Act, you know, that said, there may be tribes that have arguments, I think Melody alluded to this, based on particular treaties or statutes that are distinctive to them. You know, there may be other situations where other arguments are available. And we talked a minute ago about VAWA. And, you know, one aspect of this decision that is sort of interesting along those lines is in the Bracker analysis, the court makes a big deal out of the fact that the tribe did not have jurisdiction over this crime. And that's why it saw no significant tribal interest here. Now, obviously, I think we all disagree with that, but that was sort of their view. Now, that's not going to be true in VAWA cases, but that's also, I think, an argument that we all have to, you know, think carefully about and deploy only with care, basically for reasons that Professor Reese gave, that if you want to be in a position to push for legislation to expand tribal jurisdiction or to address Oliphant, then, you know, if folks think that the flip side of that is going to be to divest states of jurisdiction that they have, you know, that may be received differently. And so those are going to be some choices that are going to, you know, get made in litigation going forward that, you know, I think merit careful thought.
Thank you. Any other thoughts?
You know, I do have to say that the VAWA restored jurisdiction and the VAWA reauthorization, you know, it restored jurisdiction over non-Indian child abuse. And so, I mean, I think there needs to be great effort put into, again, putting the Castro-Huerta decision into a box and not letting it impact things like explicit affirmation of tribal jurisdictions such as we saw in VAWA. Now, I think that requires being able to think along two parallel tracks, which is the gist of what I was saying before. On one track, we have to recognize that this is a clear and present danger if wrongfully and clumsily applied in a broader context. And we know that the dicta in the decision was broad, and the hope is that it's limited, but there may be federal and state courts, state judges that apply the dicta broadly. So on one hand, we've got to limit that decision and properly put it in the box it deserves. Hopefully at some point that box will make its way to the dustbin of history. At the same time, we got to recognize, as others have pointed out, that there is a distinct danger here, and seeking clarification either through court cases or legislative engagement will help minimize the possibility of wrongful extension of this case. So I don't want to say, and at any point, that this isn't a clear and present danger to the fundamental tenets of Indian law. It is, but I don't think it helps the collective Indian country cause to concede the broadness of the decision. I think it's very helpful to basically try to put this in a box, fight it on all fronts, and seek clarification where you can get it, possibly through legislative engagement. One thing about legislative engagement, though, it is important to be outraged in this case, but in order to get the clarification we need, we're going to have to be very creative about enlisting a coalition of partners. So framing things in a way that potential allies can get behind is critical. And so just wanted to make those points.
Okay, we appreciate that. In a consideration of time, we'll move on to our next question. We've received several questions regarding whether this case will impact the Brackeen case, the upcoming Indian Child Welfare Act case, and Indian children currently in the child welfare system. Could the panel speak to that question, please?
So I'm happy to start. I think about this a lot because I am also working on briefs in the Brackeen case. That's what I got up and did the day after the decision came out. That's the other, right now on my computer, I've got my, little talking points for this on one side and, the draft of the Brackeen brief on the other. And I think the key point is these decisions or these cases are about two fundamentally different things. Castro-Huerta was a statutory interpretation case where the question was, what has Congress done or not done with respect to the allocation of jurisdiction in Indian country? And we've talked a bunch about why the court got it wrong on that question. I won't belabor it. Brackeen is about what can Congress do. ICWA is very express in the commands it gives to state courts and the provisions it enacts. And, the question in that case is what, is that within Congress's power? Does it violate equal protection and a few others? And they're just different cases. And I don't think there's any reason to think that Castro-Huerta says anything one way or another about the way that Brackeen's gonna come out. And really, I think the thing, at least for me, that it makes me mindful of is just the urgency to fight in that case. The need, as I think Professor Reese said, to make sure that you're doing the educating you need to do for a court that has not heard, at least some of them, all that many of these cases, and to move forward as forcefully as we can.
Well, thank you for that. And unfortunately, we have time for one more question, and this is directed to Chief Hoskin and Chief Hill. What have you heard from law enforcement within your jurisdiction about questions or any confusion about the ruling?
My answer can be brief, which is I haven't heard a great deal immediately. And so that I'd like to be optimistic and take that as a good sign. But frankly, we would welcome the dialogue because I think that is something that is needed. So to the extent we haven't heard, we'll be engaging as we do with law enforcement. One thing in terms of context of the Cherokee Nation is we have more than 100 agreements with different agencies. Most of these are cross-deputization agreements, which are decades-old agreements. We've had a long and very good working relationship. We have some other agreements concerning traffic tickets with some municipalities. So we start, fortunately, from a position of having a good rapport with all of the law enforcement, even those that have challenged us a bit during this McGirt era and have sided with the most anti-Indian governor in the history of the state of Oklahoma, Kevin Stitt. A few of those law enforcement and some of the DAs have thrown in with his nonsense, saying McGirt's the biggest threat to Oklahomans and other anti-sovereignty messages. But for the most part, we have a very good relationship. And so that, I think, is encouraging.
Thank you. Chief Hill?
I have to agree with Chief Hoskins. I really haven't heard anything from our office yet, but I do know the Attorney General, Jerry Wisner, communicated with the Light Horse as soon as the ruling came out to avoid any confusion. As far as this office, we haven't heard anything, but just keeping a relationship out there with the other law enforcement. And I know the AG has met with several of them to avoid any kind of confusion.
Thank you both for that. We're a little ahead of time, so we have one final question. What can the average citizen do to help fight against this decision?
You know, I'll just make a brief comment on that. One thing, I'm not saying that social media and the media generally necessarily moves the needle on a Supreme Court case, given the other factors we know we were up against in this court. However, it's not nothing that the governor of the state of Oklahoma launched a vicious campaign against tribes that was wholly disconnected from reality, wholly untethered to any facts. Or even a basic understanding of federal Indian law. He engaged in that assault, and then we had other folks in Oklahoma running for office parroting him, you know, saying things like McGirt is the greatest threat to Oklahomans and other very harmful anti-sovereignty comments. The idea that some implying that tribal justice systems are not competent and capable of doing what, frankly, we often do better than our state counterparts. Suggesting that there's some, and this will creep in, of course, and has crept into the Burkeen case, that there's some sort of a racial analysis that one has to engage in, and somebody might not be, quote, Indian enough. I mean, Kevin Stitt, of the many absurd and ill-informed comments he's made about being Cherokee, one of which is that he's such a low percentage of Cherokee and that his children are, that somehow that means that they're not really Cherokee, which is an incredible thing for any Cherokee father or grandfather to say, but that's a topic for another day. All of that, I think, affects the great number of policymakers and I think judges who are not as well informed as we'd like them to be. Filling that void of a lack of information are these vicious campaigns that are designed to undermine tribes by the enemies of sovereignty. This isn't going to cure the decision, and it may not avoid the next bad decision if there is one. But I think we can all collectively do an even better job and undertake more efforts to educate the public. And then that means we educate policymakers. I know I'm speaking to the choir here because this organization, both organizations, NARF and NCAI, and the tribes represented here, I think, do a great deal. I mean, I've seen Chief Hill and his team communicate really in a very effective way through social media and the media. So the tribes are trying. Cherokee Nation, I think, does its part, but I think this proves that there's a great deal of ignorance in the country. We know that, but this is a reminder of that. And I think we've got to just undertake some more efforts to inform the public about the basics of tribal sovereignty, because if we don't meet that obligation of educating people, we know that people that are bankrupt of any knowledge of Indian law, like Governor Kevin Stitt, will take their ignorance, spill it out through cable news, and do a great deal of damage in terms of our efforts to educate. And that translates into bad policy. And I think it translates sometimes into bad Supreme Court decisions.
Thank you for that, Chief Hoskin. Anyone else?
Yeah, I really think that's totally right. I think that it has become so normalized just how unequal tribal sovereigns are treated. I like to say we're treated, you know, it's ironic that there's, you know, this reference to the idea that, you know, not that Native victims would be second-class citizens without this interference into tribal sovereignty, because the reality is that it's tribal sovereigns that are treated like second-class governments in this country. And that's a real, you know, inexcusable injustice. And I think there's an easy way, you know, that I found to explain it to people, which is that, you know, if you go, you know, if I live in California, if I cross the border into Oregon and I commit a crime there, Oregon gets to prosecute me because Oregon is a sovereign and I am on its territory. tribes are the only government and jurisdiction that doesn't get to do that. And the reason they can't, is it because our governments are run by Native people, by the group of, descendants and citizens and self-governing people of the original, nations of this country? It doesn't make sense. The continued disrespect that our nations get within the family of governments here, like we should have the right to impose all of our laws, and and it wouldn't make sense for Oregon to impose its laws in California or California and Oregon. So I think putting that analogy out there with friends who don't get it, I think helps tremendously towards our nations being sort of just seen and given the respect that they really, really need for folks who otherwise don't get it. And I think just think of us within this lens of race and why should we be able to prosecute non-natives? And that's not what it's about. It's about being a government and being able to do what you need to do on your land.
Well, thank you for that comparative example. I think that's a great example. Unfortunately, we're running out of time today for today's roundtable discussion, but we want to thank all of our attendees for submitting the questions. We have kept a record of all of them, and we'll try to get answers to as many of them as we can in the coming weeks. Even though the conversation is ending in this virtual space, we want to make everyone aware that the Cherokee Nation, in collaboration with Oklahoma University, will be hosting an event later today about this case, which will include Chief Hoskin and other voices from around Indian country. The information for that event should be seen on the screen now, and our NCAI staff will drop a registration link for that event in the chat. While they do that, I want to thank all of our guests here today. We know that as tribal leaders and legal experts, your time is incredibly valuable, and it speaks volumes that you are here today to give your perspective and help us begin this conversation. Before we close for good, I do want to turn it over one last time to NARF and Melody McCoy and give her a few minutes to talk about the Tribal Supreme Court project and how it might be a valuable resource in the coming weeks and months when there is sure to be more litigation related to this case and its implications. Ms. McCoy?
Thank you, Larry. Yeah, as was mentioned, the Tribal Supreme Court project is a joint project of the Native American Rights Fund and NCAI. It was started in 2001, and its purpose is to strengthen tribal advocacy before the United States Supreme Court and improve the win-loss record of tribal interests. There were 3 cases accepted by the court and argued this term. And so the win-loss record for this term was 2-1. And they were close cases, all of them. None of them were unanimous. But I think it's, reflective of the incredible efforts of hundreds of tribal attorneys, tribal leaders around the country and professors, who support the project, devote their time to the project, to give tribal interests at the United States Supreme Court level the excellence to which our people are worthy of. So I commend everybody to that, and I look forward. Next term the court has accepted the one case already. It hasn't been scheduled for argument. Briefing is still being conducted, and that's the Brackeen case, the constitutionality of the Indian Child Welfare Act. I will say that there are about 10 other cases pending before the court at this time, including 3 brought by petitions from the state of Oklahoma. And those involve, from the state of Oklahoma's perspective, issues of who is an Indian, at least for purposes of the Major Crimes Act. So we know we haven't heard the last of things from Oklahoma. And so we continue to monitor those, and we have a website where all of the materials are posted. I'm desperately working on, there's the website. I'm desperately working on a updated memo of this entire term. Should be ready either tomorrow, Friday, or Monday. So again, thanks to everyone who support the project in one way or another. obviously there's direct support, but there's also indirect support. And there's also, the idea that, the Supreme Court practice is to some extent open to everyone, but the project, does what it does to help coordinate and focus the resources so that the level of advocacy is the highest that it can be for tribal interests before the court. The court justices are clever folks. They can roadmap their way to any result, which is what we've seen.
Thank you, Ms. McCoy. In addition to everything that Ms. McCoy just said about the Tribal Supreme Court project, I just want to reiterate that both NARF and NCAI are resources for tribal nations. And while our roles are different, we are here to serve Indian country and to find solutions to challenges such as this one. In furtherance of that mission to Indian country, NCAI and NARF will continue to engage on this issue in the coming weeks. We anticipate creating space for tribal leaders to come together in a safe environment to have honest conversations about what this case might mean for all tribal nations across the country. And we will also be convening meetings with legal experts, policy experts, and other key partners in order to brainstorm responses to this case and what responses are possible. Today was just the beginning on this issue, and we again thank all the panelists and all the attendees for taking this first step with us. We have all seen time and again, when Indian country stands united, we can accomplish anything. The Castro-Huerta decision was an attack on tribal sovereignty, but together we'll work collaboratively and come back stronger. We are resilient nations and united, and we will move forward and ensure our sovereignty is fully respected so that we can determine our own futures for our children and our children's children. Thank you all for attending, and I look forward to working with you all for our people. Gatego, we belong. Thank you.